Okay, I think we're all back. Weston versus Riverside. Morning, everyone. Mr. Quintero, would you like to reserve 5 minutes?
Yes, Your Honor. Thank you.
Okay, we're ready whenever you are, sir.
Thank you, Your Honor. May it please the court, Raul Quintero on behalf of Western Insurance. This case is on appeal from an order compelling appraisal regarding a loss to a condominium property in Marco Island, Florida. We presented two related issues on appeal. The first was whether when an insurance company denies the claim as a whole due to misrepresentations during the adjustment process, whether appraisal is ever appropriate at that time. The second is whether appraisal is appropriate, even if it could be appropriate when the claim is denied based on misrepresentations, when the case has essentially been litigated up into trial, and therefore the efficiencies that are involved in appraisal no longer exist. Let me talk about the first issue and get right to the point and what you may be thinking regarding the first issue. On November 4th, after briefing in this case, a panel of this court decided Leeward Bay, American Capital versus Leeward Bay. That case involved very similar facts to our case, except in one important respect that I'll get to. But it's essentially, it will dispose of issue one, because in that case, the insurer denied the claim based on misrepresentations. And this court agreed with some cases in the third DCA and disagreed with cases in the fourth DCA about whether in the event of a whole denial of a claim, appraisal can still be appropriate and can be appropriate before the coverage issue is determined. This court certified a conflict with three cases from the fourth DCA, the Corridori case, the Michigan condominium case, and the Demetrescu case. I can inform the court that that case is currently pending in the Florida Supreme Court. Jurisdictional briefing has been completed. No decision on jurisdiction has been made. So as to that issue, I submit that the court may issue a short opinion following the Leeward Bay case, and also certifying conflict with the three cases that Leeward Bay certified conflict with, so that this case can be a tag-along case to the Supreme Court case. I think it will also increase the chances that the court will accept jurisdiction in Leeward Bay if it realizes that it's not the only case on this and that this conflict really needs to be resolved. In fact, the court may also want to certify a question of great public importance just to increase those chances that much more.
Yeah, we have a number of these cases pending right now in our court. So this is definitely not a one or two case type situation.
Correct. And I think the Supreme Court should know that and understand that it needs to resolve this issue. But I submit to the court that you may not even get to issue number one because you may agree with me on issue number two, and that would dispose of issue number one. In this case, the insured filed the complaint before the insurance company had finished investigating the claim. The court stayed the case, abated the case, while the insured complied with the post-loss conditions, which included submitting documentation, a sworn proof of loss, submitting to EUOs. That was completed at the beginning of November of 2018. 3 weeks later, Weston denied the claim on November 26 due to the misrepresentations during the process, and we've laid those out in our brief. I don't need to really go into it unless the court wants to, because the issue is not whether there were misrepresentations or not. The issue is Weston decided there were misrepresentations and denied the claim on that basis. In the meantime, there had been a pending motion to compel appraisal that was filed in June of 2018. That motion was then heard in December of 2018 after Weston had denied the claim. And when after Weston responded to the motion to compel appraisal saying this claim has been denied and therefore appraisal is no longer appropriate. At that time, in December of 2018, the court denied the motion to compel appraisal. The case then proceeded through litigation through the entirety of 2019. There were 19 depositions.
But was that because it was premature because your client below opposed the motion initially because, one, it was premature. There was no argument about pleading it. 2, failure to name an impartial appraisal. And then 3, failure to comply with post-loss obligations. Those were the grounds of the opposition. It wasn't a misrep.
Your Honor, if I may clarify that, I think you're reading from a response that was filed in the summer of 2018. And in the summer of 2018, those facts were correct. They had not complied with post-loss conditions. We believed that appraisal was premature. And we continued with the compliance with post-loss conditions, which, as I stated, did not occur until November of 2018. And so on November 26th, I believe it was, we denied coverage, and then we filed an amended response, and that's at our appendix page 167. On November 27, we filed an amended response in opposition. At that time, after we investigated the claim, we had all the information available, and we had determined there had been misrepresentations. That's when we said that appraisal was not appropriate because we had denied the claim due to misrepresentations. And that's what was in our amended response, which is on page 167.
Okay, so at this point, you can see that they complied with post-loss obligations because I know there's numerous EUOs and everything else. So that's not an issue. And this really isn't an issue about a misrepresentation in the application. It's not really a misrepresentation in the items they sought for coverage or the number of building and units or the ownership thereof, or even a misrepresentation in the renewal of the policy, correct?
Yes, basically.
Okay, so what happens is in March 13, 2018, I mean, we're dealing with a very conspicuous, catastrophic hurricane. We're not dealing with a main break and a water break into a condo that's inconspicuous and hidden. I mean, this is a hurricane. So Weston's third-party adjuster paid $2.5 million. And the letter said their undisputed payments for covered reconstruction and repair of 6 buildings. So why is this not any different than Leeward Bay? Because that is an acknowledgement of coverage. You've never asked for it back. I know you talked about being a good corporate citizen and things like, well, that's not a legally valid defense. You never asked for it back.
Well, Your Honor, a couple of answers. First of all, on what Leeward Bay held, we agreed that this comes within Leeward Bay, except for the fact that now we have litigation and we're ready for trial. That was not.
Yeah, but it seems to me that you may have a very valid argument, because I think all three of us agree that appraisal seems to be a free-for-all process without any type of procedure or evidentiary rules. And I think that's your problem, is you're done some substantial discovery and you don't think that appraisal is going to save any time or money like it's intended to. I appreciate that argument, but doesn't it boil down to whether this judge abused his or her discretion at that point?
It does, Your Honor. And in December of 2018, the judge denied the motion to compel appraisal. The judge exercised her discretion in December of 2018 to deny the motion because we had denied the claim. And she agreed with us that at that point, appraisal is not appropriate. We do believe and submit that it is an abuse of discretion to then allow the parties to proceed through litigation, to take 19 depositions, to file motions for summary judgment, motions in limine.
Mr.
other
Quintero,
profile
Mr.
motions.
Quintero, can I ask kind of a first order question about this argument? The argument that you are presenting, that it amounted to an abuse of discretion for the trial court to now compel the parties to proceed to appraisal, necessarily revolves around the notion that the appraisal process, such as it is defined in your client's policy, which doesn't really tell us very much, is, I guess, inherently and inescapably there for the purpose of mitigating costs and avoiding litigation costs, something like arbitration, I guess. That seems to be an assumption without a proof. I get it that the appraisal process might have the incidental benefit of saving time and money by virtue of the fact that you appoint two appraisers, they choose an umpire, they go through the list of items, and they look at their they plug in their computer programs and come up with whatever their programs tell them is the reasonable construction value of each of those items. But I question whether or not that is in fact anything that we can go off based upon the policy's language. And I'll give you the flip side of this, and I'd like to hear your thoughts. Couldn't it just be argued that the only reason, the appraisal process is fully served so long as appraisers are deciding the issue of valuation of disputed items that are covered, and not a jury? In which case, the court did not abuse its discretion because it is doing what the appraisal process arguably is designed to do, which is have appraisers decide something rather than a jury.
And I just add one point to that. It does save the cost of the trial, which any of us who've tried these cases before know that's the lion's share of the legal bill.
I agree that it may do that incidentally. I am just wondering what in the policy tells me that's why that is there.
Well, Your Honor, let me try to answer that umbrella of questions.
There's a big one.
You're up to it, Mr. Cantero.
Thank you for your confidence. I think that when these provisions were first drafted, the theory was that it would save time and effort and money and get the proceeds to the insureds faster than litigation. I'm not sure that it's always worked out that way. And the problem, there's a lot of problems with appraisal in these days. One of the problems is that, as happened here, many times one of the parties, the insured in this case, will assign its own adjuster, its own public adjuster, as its appraiser in this case. So we don't have.
Our court just addressed that, by the way.
Yeah, I did see that actually yesterday, I think it was, yes. So that really doesn't help anybody when you have non-disinterested appraisers doing this. And the second answer, and also an answer to Judge Morris, it doesn't save the cost of a trial. It saves the cost of having the jury determine the damages at trial. But in this case, everybody agrees. Even the insured agrees, the trial court agreed. Our affirmative defense of misrepresentation and voidness because of those misrepresentations will need to go to a jury regardless of whether there's an appraisal before or after or not at all. So it's not going to save any of those costs except one or two more questions on the verdict form that say, what's the amount of damage?
Well, but the crux of your arguments are that there was some damage that was pre-existing, or there was fences that weren't existing at the time of the storm, or things like that, which are clear misrepresentations that the appraiser could identify too. I mean, there's case law that if you haven't wholly denied, and I'm not so sure that you've wholly denied, given that you paid the 2.5 and declared it covered. I'm not sure that's a full denial. But the appraisers can, at the very least, boil down and distill down the amount of damage and the scope of repairs, then the jury at trial, it's more of a condensed trial, I think you would acknowledge, but the jury can still weigh in and consider what the evidence that you have in terms of concealment, lies, false misrepresentations, or anything else, and mitigate the damage even even below what JS held, estimated at 4.7 or 4.6, what have you.
Well, the insured would argue that once the appraisers determine the amount of loss, that we're stuck by that amount at trial. In other words, it's either the amount that the appraisers find or it's zero because the policy is void for misrepresentations. That's going to be their argument. Our argument is that we have the right to present all our evidence on misrepresentations. This is what they said, and I will tell you about, to go to page 853 to 855 of our appendix, which is essentially a chart comparing what they said were damages and repairs necessary and what our experts said were the damages. And he goes through and itemizes those on pages 853 to 855 in our appendix. So we're going to say they claim $38 million in damages. We say it's 4.2. That's a discrepancy of 33.7 million. Our experts will have to go through and explain to the jury why those discrepancies exist, why, for example, all the windows and doors don't need to be replaced. Some of them
Mr.
do.
Quintero, you're at 16 minutes, just so you know. It's your time. Use it however you choose.
Thank you. Some of them will need to be replaced, but not all of them. And so there's no efficiencies at this point where we've gone through all of the litigation and spent hundreds of thousands of dollars in litigation fees to then go to appraisal, to then come back and have a jury trial. Before I sit down, I want to finish answering Judge Sleet's question and concern about our payment. Our payment was done before we had the documents and EUOs in March of 2018, like you said, and we paid $500,000 per building for 6 buildings. And we essentially said, this is to get you started, to do the remediation necessary. We may pay more later, we don't know, but we haven't investigated the claim. So that's a good faith effort to get an insured back on its feet, remediate things that need to be remediated before it even conducts an investigation about what the damage is. They have not asserted waiver as a reply to our affirmative defense. They've never argued that we waived it. They've said, as a matter of fact, that we did make the payment, but they haven't made a specific waiver argument where they went through all of the factors needed to determine waiver. And so I believe that should not be considered in determining whether and why we ultimately denied the claim for misrepresentation. Those were all done before the investigation. I'll save the rest of my time for rebuttal. Thank you.
Okay. You'll have 2.5 minutes when we come back.
I'll have to talk fast.
Okay, Mr. Boyle.
My outline says good morning, but good afternoon. And may it please the court, Mark Boyle with the firm of Boyle, Leonard & Anderson, and I represent Riverside Club Condominium Association. As the court has already discussed with my opponent, the legal issues which are raised in this appeal, in our view, are entirely resolved by the recent American Capital Assurance decision versus Leeward Bay, which decision the mandate issued on December 30th. Obviously, the case is headed to the Supreme Court.
Regarding Leeward Bay, do you see a similarity with the $76,000 payment made by American Capital before they denied the policy or denied coverage based on misrep?
Yes, Your Honor. The Leeward case explicitly holds that, and my opponent has conceded this, so I won't spend a lot of time, that this defense of fraud is not a legal barrier to proceeding. And I would note that the case, I think, pretty explicitly addresses the second point as well, recognizing on page 3 of the version that I'm looking at and in a couple of other places that the decision in light of that is a discretionary one about whether to proceed to appraisal first. I would adopt the arguments Judge Lucas made, and I'd add a few others.
I'm out of the argument business. I'm just raising a point that we have because we have been seeing a lot of these appraisal issues come before us, and these provisions read very fairly similarly. There's not much to them. It doesn't, the policy doesn't tell us why they're there, what purpose they're serving, which isn't terribly surprising, but it just seems to be that everyone is assuming that the purpose of appraisal is to save everybody money. And maybe that's true and maybe it isn't. I don't know. I wonder whether or not it's just simply, it may do that, or maybe it's just that the insurers believe that having an appraiser panel decide the issue of valuation of a covered loss is better than having a jury decide it. Just status quo, all things being equal.
So I have a couple of comments in that regard related to my long prior history of representing the insurance industry. Now I represent policyholders. When your name is insurance company and you're facing a jury, that's not an optimal situation. So
Right.
the court, that may well be one of the reasons. I take at face value, frankly, the idea that in some circumstances, most circumstances, there'd also be a saving of time. But I don't, as the court points out, that's not necessarily dispositive.
Well, it likely facilitates a settlement too, don't you think?
And my next item in my note that I wrote down from the argument is, the court may well have sent this case to appraisal hoping that an amount of loss decision would facilitate a settlement. That's part of the discretion any court gets to exercise when they're severing or trying one part of a case or another, or deciding which one goes first. And as we noted in our brief, while they're complaining that we got all the way here, they told the trial court in the initial two motion, the motion and the motion for rehearing, that she didn't have any discretion to send this case to appraisal at first. And she quite clearly believed that. If the court sees the history, it's only when the per curiam affirmance case was presented to her with, as the court noted, several of these cases. By the way, Judge Lucas's opinion in that Parrish case, that's my case as well. These appraisal issues are percolating at high levels in the second district. I agree with the court's comment that, I'll rephrase it, the appraisal provision is kind of a wild west, and there's all kinds of different levels of.
That was my thought exactly.
There's all kinds of different levels of formality that apply. I've been an appraiser, an umpire.
Mr. Boyle, can I ask you a question though about this, the clause in the insurance contract that basically allows the insurer to deny coverage based on fraud, misrepresentation, things of that nature. Is there any magic to when that fraud occurs, fraud or misrepresentation occurs? Judge Sleet, in his initial question, I think to Mr. Cantero, pointed out specifically that this was not a fraud or misrepresentation in the underwriting of the policy or any of that. This occurred simply in the submittal of the claim. And clearly, if it occurred in the underwriting of the policy, I don't think we'd be here arguing about it. It would be, they have a right to deny coverage under the policy, and appraisal is not appropriate in that situation. But is there, after the fact fraud, does that make a difference?
That's what this court's opinion in Leeward holds, and as does the third district. And I think rightly so, because it's a recognition that the type of fraud that's being raised in this case, and it might depend on the type of fraud, the type of fraud being raised in this case is primarily a dispute about the scope and amount of damages.
So is there a strategy too about not asking for a refund of the 3.2 million paid out on the claim? In other words, is that a conscious strategy? Don't ask for it back, because we want to be in a position to say that, coverage was acknowledged and that sort of a thing.
You'll have to ask my opponent what their strategy was in not asking for it back. I don't know.
Well, would it make a difference? Would it make a difference if that had been done under an ROR, the 2.5? It wasn't. But
this is a point that I brought up with the trial court. It's not part of our record for this appeal.
Okay.
Yes.
Well, let's move on, because I have another question. Let's just assume you go to arbitration. Appraisal. I wish it was arbitration or the rules applied, but I haven't done an appraisal, so I don't know. But it concerns me, the lack of procedure and evidentiary rules. But let's assume that they arrive at an amount of damages, as Mr. Quintero says, that he's That's law of the case in terms of damages. I just don't see it that way because the policy is not written that way. It's construed against the insurer, and the insurer is not clearly in the policy that the appraisal amount is set in stone. Is it?
I think the appraisal panel's determination about the amount and scope of damages is binding on both the parties. And frankly, it may resolve some of the issues that are alleged frauds, and I think that's what the trial court was thinking. I'll give the court the easiest example in this case. The party's biggest dispute is whether the windows and sliders in these units needed to be repaired. Fundamentally, the insurer says no, my client says yes. And if the appraisers determine that those did need to be replaced, that at least takes that issue off the table. There are other issues they're alleging as
Yeah, wasn't there an issue of a wrought iron fence that never existed?
there was.
And lanais that are beyond their useful life?
There are those issues and a couple of others.
Well, it also seems that in open court during a hearing, and I can't remember which side represented, it seems to me that the Riverside is now down to 26 million as opposed to 40. Am I right?
The party's
Correct.
damages experts were not done, but generally that's correct. The damage number was lower by the time the case got to the stage it was going to be tried. That's correct, Your Honor.
So, Mr. Boyle, I'm just wondering, and maybe this is just kind of nitpicking at I'm still bugged by the policy provision regarding appraisal because it really doesn't tell you much of anything. It is your position then that whatever the appraisers come up with becomes basically law of the case, and the judge can't reject it, except the policy just says the appraisers will state the value of the property. They will appraise it. It doesn't really tell you what you do with that, right?
I agree with that. And the rule of construction against the drafter would apply to that lack of clarity.
The mediation provision that immediately precedes it talks about mediation, and we all understand mediation is a process, and there's a settlement agreement that is if you settle, you reach and that becomes a binding contract, et cetera, et cetera. Here, it doesn't tell us anything. How does that inform our review? The fact that the appraisal policy that's before us just says they make an appraisal, and I get it. Everybody's assuming that appraised value is basically the equivalent of an arbitration award, even though it doesn't say that. How does that inform our review of the judge's discretionary call here on issue 2 of the insurance company's appeal here? Or is it just simply, the fact of the matter is this is, like you said, the Wild West, and so discretion here is really wide? I don't know. What are your thoughts on that?
I have two thoughts. One, there are all kinds of different levels of sophistication of appraisal provisions. And to the extent that this is ambiguous, it's an artifact of the one that's in this policy. I still call him Justice Cantero. Justice Cantero and I both have been involved in cases where there are more sophisticated, more detailed provisions regarding appraisal. So they're available. They're in the marketplace. They're not in this case.
Right.
But in terms of how it affects what the court's doing today, I respectfully submit it shouldn't have any impact on it. This is no different than any discretionary decision to sever one issue, liability or damages. Trial courts do it all the time, sometimes really early.
But you see, the problem I'm bumping up against is that I don't know what it is that the court, if you don't understand fully based upon a plain reading of this policy provision, what it is that the appraisal process entails and how it goes about and what it's supposed to do, how do you ever figure out if a judge is exercising his or her discretion properly?
That absence of clarity presumably went into the trial court's decision evaluating this.
I guess. I don't know, because I don't know what this provision is aiming for, how it's supposed to be implemented, and what you're supposed to do with it when it's finished.
The fact, I admit I'm making an assumption about the judge's knowledge, but the amount of these cases that are percolating down at the trial court level in the 20th Judicial Circuit, and I don't know how, Judge Lucas, you keep pulling the short ping pong ball and ending up in appraisal panels.
I would say it's because I'm one of the newer judges, but I know that can't be it.
The judges have some familiarity with how this process is working, and I respectfully submit whether it's making cases disappear. One last comment I would make. The court will recall we were continued in late April. This case was never going to trial. The pandemic happened, right? We were scheduled for a 3-week trial, and the pandemic was never going to let this case be tried.
But what are we supposed to do about that? I mean,
I
you made
think-
that point in your brief, and I thought that's a good point. But what's it? Does it really have to do with anything, or is it just a practical consideration?
It goes back to the question of whether the case might settle. The court might well realize we might not be trying this case for
Yeah.
many months. And the decision to send this to appraisal might cause a settlement.
Okay.
Not, but it might. But that's an element of her discretion that she's allowed to have applied to the facts that she had.
Well, does
Yeah.
the fact that Mr. Quintero talks about the significant substantial discovery performed up to date and you're ready for trial, does the fact that that has occurred and been accomplished, does that support your argument for appraisal? Does that mean that they have now a big cache of evidence with which to review or not?
I think it cuts both ways, meaning I accept their argument that means some of the efficiency, if that, as Judge Lucas points out, is one of the reasons for appraisal. Some of it is lost, but it also cuts in the way the court mentioned, meaning that now the appraisal panel is going to have a lot of information to work with. And appraisal panels, sometimes they do allow discovery. Sometimes they don't. Sometimes they just proceed on the expert testimony. I'm trying to limit myself to the record. So I better not make my additional comments because they're not in the record in this case. I have a lot of familiarity with this process. So does Justice Cantero. So I don't want to poison the case, the panel with my impressions of how it works.
But our record doesn't bear out how you two intend to proceed with appraisal if we affirm.
I agree with that, Your Honor.
Okay.
With that, I have no, unless the court has further questions, we'd rest on the Leeward decision, which we think answers both questions. And we'd ask that the case be remanded to be sent to appraisal.
Thank you, Mr. Boyle. Mr. Cantero, you have 2.5 minutes.
Thank you, Your Honor. I want to be clear so this court is aware, no case that either side has cited, and we've cited many, has sent a case to appraisal or has affirmed the sending of the case to appraisal after the case has been litigated.
Yeah, but the pandemic, does that matter? Does that change? I mean, does that all this, I mean, that's a wild ball, right? And we don't know what to do with that, but maybe this judge said, I can't have a trial. These people have worked hard on this case. I'll send it to appraisal when I ordinarily wouldn't because of the circumstances.
No, this case, the court made this decision before everybody closed. The hearing was on March 9. And I remember where I was in that time, everything didn't close till mid to late March. Nobody discussed the pandemic at the hearing. I'll tell you why she sent the case to appraisal, and it's on page 532 of our appendix. She asks, let me ask you this, and not that I want this to be a test case, but as I'm looking at how this is going to proceed, if I were to grant the renewed motion, would you then appeal and then we can get some direction? And the reason she said that was because the sole basis for the insured's renewed motion to compel appraisal was this court's PCA decision in the residences. And we made the point at the hearing that you can't rely on that this got no precedent. And
It was
so
a PCO, wasn't it? Wasn't it a
I'm
PCO
sorry?
cite to a case?
It was, cited 2 cases.
Yeah.
Yes, citation PCA. And we said, you can't rely on that as any precedent. And that's why the court said, well, we need some direction. So if I grant the motion to compel, will you appeal? And we said, we have to consult our client, but I think we would. That's why she sent the case to appraisal when she hadn't before. No case has ever, as I was saying, sent this case to appraisal after litigating the case and right before trial, because the whole purpose of the appraisal is to, as we've been discussing, save time, save money, perhaps settle the case because the insurer said some items are covered, but some items are not. And maybe after the appraisal, it's not worth fighting over those amounts, depending on what they were. Mr. Boyle also said that we invited the error somehow. First of all, the invited error doctrine has never been applied in a situation like this. We told the court back in 2018 that because we had denied the entire claim, appraisal was inappropriate. At that time, this court's decision in Leeward Bay obviously had not come out. The residences had not come out. What the court had to go on was the 3 decisions from the 4th DCA, which have held unequivocally that when you deny the claim in full, appraisal is not appropriate, at least until the coverage decision is made. That's why she denied appraisal at that time. And assuming that was an exercise of discretion, it was a proper exercise of discretion. And that's when this court should say, whatever the wide discretion is that Judge Lucas talks about, that discretion needs to be exercised at the beginning of the case, not after the litigation has proceeded through the entire thing until the eve of trial. That is not when you exercise your discretion. You exercise it at the beginning. Unless the court has other.
You're out of time, sir.
Yes. Thank you very much for your indulgence and your time.
Yes,
And I
thank
ask
you
to
both.
reverse.
Thank you both.
Yes.
Happy New Year.
Yeah,
Happy
thank
New
you
Year. Thank
both.
you.
Excellent presentation. Thank you both. We are
Thank you.
adjourned to deliberate.